Thank you, Your Honors. May it please the Court, Chance Lyman here on behalf of the appellants. I'd like to reserve 5 minutes for rebuttal. This is an appeal of a nearly $70 million jury verdict in a medical negligence action, $50 million of which is non-economic damages. Now, I plan to I want to focus on the Fabre issue this morning because it's the simplest basis for reversal and it requires a new trial on all issues. All this court has to do to reverse is apply the plain language of section 768.81, which the trial court rewrote to preclude Cogent from presenting its substantive statutory defense to the jury. This is a denial of due process, and it's one that requires a new trial on both liability and damages, particularly here where the record reflects that the judge even agreed that the culmination of what happened at trial created a manifest injustice and all sides agreed to a mistrial. Now, I want to turn first to the statutory language, particularly the 1999 amendments. I think that's significant here. It explains why most of the cases on which the plaintiff is relying, the trial court relied, are an opposite here. In 1999, the legislature amended 768.81 to create a substantive right for defendants to name Fabre non-parties both as practically as possible and to raise the defense via motion at any time before trial. And I just want to emphasize that.
Justice requires. As justice may require, which you seek to ignore.
That language does not come from the statute, Your Honor. And what the statute says is any time before trial. And it doesn't just, I just want to emphasize, it doesn't say before trial. It says any time before trial. So the language justice requires says leave to amend should be freely given when justice requires. That comes from the rules of civil procedure. So
having incorporated rules of civil procedure, doesn't it necessarily contemplate the case law interpreting that rules of civil procedure?
I don't think so, Your Honor. I don't think it brings the soil in with the case law interpreting the rule of civil procedure. It says in accordance with the rules of civil procedure, and it doesn't even specify which rules, but to the extent we're talking about 1.190, 1.190 doesn't mention timing either. In fact, the only...
The Supreme Court adopted the rules, left it to the courts to fashion. And it's like how a lot of rules of civil procedure work, which is you have a kind of broad, especially when it deals with discretionary acts, you have broadly worded language that guides the trial court and the courts over time interpret that broad language in order to provide more clear guidance. So why wouldn't, I'm struggling with that part of your argument that no, the statute only meant by mentioning and incorporating rules of procedure is only the text of 1.190 and nothing else came with it when the legislature is presumed to understand state of common law whenever it adopts the statute. Help me through that part of it, please.
It really is the 1999 amendment adding the language any time before trial. That was arguably an outgrowth from Nash, which did talk about Rule 1.190. But what the Supreme Court's Nash Court says is you need to do this before trial.
Well, but doesn't any time mean anytime you learn? We all know that now. You guys get the benefit of a pre-suit investigation, assuming Cogent hired competent attorneys. They knew all about Dr. Decker before the plaintiff could even file suit. You knew the strategy, assuming you're competent, you develop the strategy. Anytime means anytime you learn. You knew about Decker. They canceled Decker's deposition in March of 2022. That would behoove you to get on the phone with Decker's attorney saying, you guys settled yet? Have you settled? Which I'm assuming these days attorneys don't use phones anymore. So what happens is Decker's dismissed September 2nd, 2021, right?
Right.
Nobody does anything. Nobody moves to amend to say Decker did this, that, and the other thing, because the rule does say identify the non-party, which y'all never did until after pretrial, the 11th hour, and if known, describe the non-party as specifically as practical. You know about Decker because you had the records in pre-suit. You could say exactly what he did. The first time you said exactly what he did was after pretrial, right before trial. So anytime can mean anytime you learn. You didn't do it when you learned, not you. The trial lawyers never did it when they learned.
So, Your Honor, I don't think that the statute says any time before you learn, or any time
What's
when
the
you learn.
reason? Okay, so I'm in the middle of trial, you're gonna sit here and tell me, after having all the pre-suit, that you just discovered, oh my God, I just read that one report where Dr. Decker ordered the wrong diagnostic study. I think I need to add.
The answer to that, Your Honor, is the vicarious liability claim against Pioneer, which, by the way, was never dropped. It was literally never dropped. Now, our contingent Fabry defense was already sufficient under the statute because the core concept here is notice. We told the plaintiff exactly what was going to happen if and when they took an action that we could not control, by the way.
But when we were asked in discovery, name other doctors that are negligent. Your trial attorneys didn't name anybody. They just simply said the nurses may or may not have done the catheter wrong.
Well, they also said we're not currently contending. That's the language in the interrogatory. Now, I'll explain. If the plaintiff's vicarious liability claim against Pioneer is in the pleadings, which it was when we answered those interrogatories, and by the way, Dr. Sweet's deposition hadn't been taken at that time either, but if the plaintiff's vicarious liability claim remains pending, the plaintiff is presenting the evidence of the negligence. The plaintiff is going to argue that there were breaches of the standard of care. And of course, that's what they had done.
The plaintiff dropped those experts before trial.
Actually, Your Honor, the plaintiff never dropped Dr. Sweet. The experts whose depots were canceled, those were the Pioneer, experts favorable to Pioneer. They were the Pioneer doctors experts.
But
So-
your focus in your brief appears to be Decker, whose outrageous conduct.
That language comes from Dr. Sweet, the depot that didn't exist when we answered the interrogatories. So again, the interrogatory is absolutely consistent with what the contingent Fabry defense says, which is, we're not currently contending the defendants are negligent, but if you drop them, and that means if you drop the vicarious liability claim against Pioneer, which is substantively based on the individual doctor's negligence, we would be entitled to apportionment.
But you're not telling the plaintiff how and why you would be entitled to. You just simply said, if you drop them, we're able to apportion. You already knew exactly what each and every one of them did and didn't do, and this requires you to tell them.
We did
It's
tell them.
called notice pleading.
We did tell them. We told them, your allegations allege negligence against these parties. If you drop those parties, we will be seeking entitlement based on their liability. That's what the contingent one said. Now the amended one, which comes a week before trial, couldn't be clearer, Your Honor. I mean, it details we're
Why
relying.
did you wait to name Decker when Decker had been dismissed in September 2021?
Well, we couldn't do that while Pioneer's vicarious liability claim still existed, and to this day, we don't know when.
Well, what law allows you not to name Decker?
It's again, the concept of notice. If we had named Decker,
Notice.
yeah, absolutely, Your Honor. And we gave the plaintiffs the notice that, by the way, if and when you drop Pioneer, which they never told us when they did it, and we can't control that, Your Honor. We can't control when they drop Pioneer. So the notice, the keys to the notice were in plaintiff's hands. And if plaintiff is allowed to manipulate the trial strategy the way that happened on this record,
Well, the unanswerable that I can't fathom from the briefing is your client really wanted to have continuance. And it seems that springing this after pretrial conference, if you had been successful, you would have shifted to the plaintiff and the need to ask for a continuance. That's how I see this playing out.
well, in that case, Your Honor, first of all, this court's Thompson decision, which we cited in the briefing, that's exactly what Thompson says. It says leave to amend needs to be granted, and if there's a prejudice, ask for a continuance. And more fundamentally, Thompson wasn't addressing the Fabry statute. The Fabry statute is really critical here. Because if you're in a scenario, and this is a legislative mandate, if you're in a scenario where a defendant raises the Fabry anytime before trial, and you are in fact prejudiced, then yeah, you do need to request a continuance. That is what the legislature has told us. But more fundamentally, they didn't need a continuance. We were using their expert, their evidence.
You were using their expert as standard of care experts.
We would have used Dr. Sweet to opine on the breach of the standard of care by the pioneer doctors.
The plaintiff would then have to turn around and defend them.
Absolutely, Your Honor. I mean, that is the statutory framework.
It sounds like strategy to me.
There was
Your
strategy.
strategy was you made a bad strategic decision to name Decker too late. You had an opportunity
we
to
could not-
amend your affirmative defenses. You tried to amend them before, and you never named anybody, nor did you specify what negligence, even though you knew, because you had all the hospital records before Mr. Trinlodge ever.
This is absolutely true, Your Honor.
Yeah, absolutely.
But again, when we see notices of dropping these parties, and don't see a notice dropping Pioneer, we're entitled,
Call it ask.
Love a call.
you know, I don't think the record reflects.
Decker, don't you think somebody else is gonna be dropped?
Well, actually, so the Decker drop comes in 2021, and the other Pioneer doctors weren't dropped until later, but in any event, the plaintiff's pleading spells this out. Paragraph after paragraph of negligence detailing what the individual Pioneer doctors did. But then in the end, you see this vicarious liability claim that, again, Your Honors, it was never dropped in this case. It was never dropped. That vicarious liability claim says all those other allegations that I just alleged against these individuals, they're Pioneers liable for. Now, what that tells any defendant on this record is the plaintiff is presenting negligence of these four people's, plaintiff evidence of these four people's negligence during trial. I need to prepare a trial strategy based on that.
Even though he didn't do that, the trial transcript shows that your client had ample opportunity to blame all of them.
During trial, Your Honors,
Cross-examination, including Dr. Decker and his outrageous conduct. You were able to effectively argue that to the jury.
Your Honor, I don't think that we were able to effectively argue that to
They
the
did
jury.
a cross-examination about him being part of the team and being the quarterback.
Sure, but that's the tip of the iceberg. And more critically, it doesn't address the verdict form issue, which is a substantive problem here. But even if we did present a tip of the iceberg,
Well, help me out with that. I'm sorry to cut you off, but, because this was something that I kind of questioned as I was reading through everything, which is, you talk a little, kind of in broad meta terms in terms of how this would have changed the whole aspect of the case. But is there anything in the record where you all like made a proffer that we would have asked these questions, or we would have elicited these exhibits, or we would have put in these records, if only we could have been allowed to plead this Fabre defense?
absolutely, Your Honor. We proffered doctors at the record at page 9,693 is a good example. That's a proffer of Dr. Sweet's standard of care opinion that we were not allowed to present to the jury. Well, Your Honor, this is what Dr. Sweet says. If the neurologist doesn't show up, all is lost, and that's what happened here. That is not something that we were allowed to bring out at trial. The other really glaring problem with the tip of the iceberg notion here is, look at the way plaintiff
I
argued.
think what I was looking for was maybe something independent of the standard of care, or excuse me, I was looking for something independent where you had some line of questioning that just wasn't coming in at all.
Well, we did.
Or records, or medical, there's these records, we just could not get them in, but for Your Honor's ruling on Fabre, on our ability to serve Fabre.
Well, we absolutely during cross-examination of Dr. Sweet, we mentioned to the court, I want to ask some questions, and I believe your Fabre ruling is going to preclude them, and the court confirmed that in a ruling. It said, yeah, ask him what he did, but you can't, even the appellee's brief says we were not allowed to elicit the standard of care testimony that could have resulted, that they don't say this, but it could have resulted in a complete defense verdict on the record here. And the issue is, we really just don't know because evidence was excluded. And that's, again, what this court really held in the USF Carter case. And Judge LaRose, I know you're on that panel. That is what happened here. There was a pre-trial exclusion of a substantive standard of care expert discussing a causation defense, certainly an apportionment defense, and it was excluded pre-trial on an error of law under the Fabre statute.
So that's where you're tying all that to, is that exclusion of that expert.
Yes, and corresponding questions to Dr. Decker, for example, testified via deposition. If we were allowed to present this defense, as we expected to pre-trial, then certainly decisions were probably going to be made to make sure Dr. Decker testified. I think there's actually another comparison to the Carter case in that plaintiff kept saying, we're going to be having Dr. Decker here, we're going to be having Dr. Decker here, and then didn't have him, and then just eventually did the depots. That's essentially what happened in the Carter case, by the way. Plaintiff kept toying with the idea of presenting this testimony from one of the critical care experts, and then at the last minute sort of doesn't do it. What happens? The defendant proffers the evidence, just like we've done here, and again, this court reversed because, of course, that was an error in not allowing a Fat Ray defense that should have been presented. It really has to do with the substantive evidence, and Judge Lucas, on pages 15 and 16 of the briefing, and Judge Sleet too, this is where we're discussing the proffer. It's the evidence that we would have presented. It is the line of questioning. I don't think there's anything insufficient about submitting the deposition testimony as a proffer. And again, I just want to emphasize that there are statements in here that the neurology team was the sole proximate cause of what happened. I mean, that's why the patient deteriorated the way she did, is what Dr. Sweet has to say. And oh, by the way, I need to emphasize the significance of Dr. Decker's involvement. He's really the only person who's here, who's responsible for the care the entire course of what's happening. He's the first person who's called once the plaintiff gets to the emergency room, and it's really that call, by the way, that Dr. Sweet was so upset with, that he said was the outrageous violation, something like a gross violation of the standard of care. Now, there's one other really important way that this affected the trial. Look at the closing argument, the way the plaintiff presented the closing argument. They said Dr. Sweet is the best expert in the room. I'm paraphrasing. Dr. Sweet, I think they said, is the one person you heard from today who really ties it all together. Now, while they are saying that, Cogent's hands are tied behind their back. We want to tell the jury that if you believe Dr. Sweet, if you really think that Dr. Sweet is the one person who ties all of this together, he tied it right to the neurology team.
Was there an objection?
During closing? No, there was not an objection. Well, we were already precluded from presenting the Fat Ray defense. There would have been no need for an objection at that point because we had proffered the testimony we needed. By the way, the error I'm talking about here is pre-trial. Again, I need to focus on that. It is a pre-trial error, and that's very significant, obviously, for our argument about the scope of remand. But I really I have to go back to the statutory language. This is a plain language construction of unambiguous statutory language. Any time before trial. It doesn't say any time once you learn before trial. And oh, by the way, even if it did say that, this is the gamesmanship on the plaintiff's side here. This is the significance of dropping,
There was gamesmanship on both sides. Let's be honest.
Well, and
There
Your Honor,
always is. Plaintiffs' attorneys and defense attorneys do it all the time, and there's nothing wrong with it.
well, Your Honor, two wrongs don't make a right.
I understand that. But let's be real. There is
But you have the burden on appeal.
Yeah, you do.
Certainly. By the way, it's a de novo review. I want to mention that. I know we're debating in the briefing about the standard review. It is not an abuse of discretion review. It is a de novo review. Why? Because the trial court rewrote the statute.
But what did you affirmatively plead? You just simply said that if they're dropped, we get the right to apportion. Apportion what? What did you affirmatively plead?
Apportion their liability. We said,
What, based on what?
Based on
There's a bunch of specialties in this case. You didn't say a word about that. That's what Judge Huey said. You didn't say a word about it.
So-
Okay, if Decker talked about neurology, what he didn't do. If it's the other people, critical care, talk about what they did and didn't do. You never did.
not to ask a question, but if you're referring to the interrogatory responses,
No, I'm not. I'm talking about your
So the-
amended defense still doesn't say what they did or put the plaintiff on notice of what they have to defend.
it absolutely does, Your Honor. It absolutely does. It attaches their sworn interrogatories detailing the negligence of the Pioneer doctors. That is absolutely part and parcel of what our defense is at the motion stage. By the way, the legislature tells us you can do this by motion. And when it says accordance with the civil procedure rules, it can't, the civil procedure rules can't rewrite the timing language that's very clear in the statute. Civil procedure rules can tell us, look, when you file a motion to amend your pleadings, you better attach the proposed pleading. That's what in the accordance of the rules means. It doesn't mean, oh, by the way, let's import the soil from 1.190 regarding a prejudice analysis. Courts cannot conduct a prejudice analysis.
I just have a hard time, and this, I know this goes full back to what we were talking about. I just have a hard time fathoming how the legislature would explicitly incorporate the Florida Rules of Civil Procedure, and the legislature is presumed to understand the state of common law whenever it enacts any enactment. And your argument is that the intent was to excise all of the case law interpreting all of the Florida Rules of Civil Procedure for this one statute. I mean, that would be a really novel proposition.
I really think, Your Honor, that the answer is that
I mean, that is, am I accurately summarizing your position? That it is literally a pure text adoption of Florida Rules of Civil Procedure, excise of all the common law that's ever interpreted. That is the position you're advocating.
it is, Your Honor.
Okay,
It is. And now,
I appreciate the candor.
I'll explain a little bit more. Leave to amend shall be freely given when justice requires. Nothing in that rule talks about timing, nothing talks about prejudice. Now, justice requires courts to follow the unambiguous plain language of statutes. That's what justice requires. If that's the import of that's happening here, then that's what that language has to be.
I gotta call that out. What you just did was you used the word justice as a way to mallet out any concept of justice other than what's in the text. But the text uses the word justice, which means even under the lex of your argument, that term is nice and capacious, that prejudice could easily fall within the rubric of the term justice, right?
I don't think so. Let me explain a little bit.
I'll let you explain, Chair, 5 minutes.
Okay, last point then. It really has to do with timing. Now there might be aspects of prejudice that could remain under that theory under the word justice, but it certainly can't control the timing factor. That's because any time before trial means any time before trial. Nothing in the civil procedure rules or the case law, which by the way, there's no case that interprets the statute. Nothing could be said to override that legislature's timing mandate. Thank you.
Thank you. I'll give you the full 5 minutes. Good morning.
Good morning, friends. My name is Kristen Norris. I'm close to Stuart Martin of County Department in Pelham. I represent Miranda Crowan. This is a limited appeal, despite the mention of the size of the verdict. The size of the verdict is not at issue. The jury's well-supported finding that it was negligence and not an unstoppable disease process is well supported by the evidence and not challenged. So what this appeal boils down to is 4 highly discretionary procedural rulings. And because my opponent has focused on the Fabry, I will do so as well. And there's 3 reasons that the trial judge did not deny his discretion, did not abuse his discretion in denying this amendment. And the first of those really is the dispositive one, because regardless of what the statute says, Cogent waived that defense. They affirmatively stated in their answers to interrogatories that they were not going to assert it. They were actually directed by the trial judge to give Fabry. They had to be compelled to answer those interrogatories because they said it was work product. Case law directly on point, preventing that. So the court said, you have to give Fabry. That's important. That's how we get prepared for trial. Instead of doing that, they answered 5 separate interrogatories. Interrogatory number 4, whether or not they were asked to detail any act or omission by any party that was negligent. They said, Cogent does not currently contend any party in the lawsuit was negligent. Interrogatory number 5 asked if they would rely on, to state the facts, they would rely on to support any affirmative defense. They did not answer that as to their conditional Fabry defense. Interrogatory number 6, do you contend any person or entity other than you could be liable for this injury? They mentioned the hospital. They didn't mention any doctors. Interrogatory number 24, do you contend any other treating physician or nurses, including named defendants, were negligent? Cogent again points to the nurses, not to any other doctor. And
What
interrogatory,
year did they file those responses?
that was on July 1st, 2022.
Okay.
So their
Before trial.
explanation, they have 2 explanations on this. The first is, well, Pioneer was still a party. Okay, well, Pioneer got dropped as a party, and all the individual doctors were already not parties. So if they wanted to do the amendment, they had every right to do the amendment, nothing prevented it. But they said, well, Pioneer wasn't a party. Well, Pioneer got dropped on September 16th. There's no confusion anywhere about when Pioneer got dropped. It was stated expressly on the record in a filing in response to one of Cogent's second motion to continue. So, and the motion said, and we're going to cancel the expert depositions of Pioneer's experts, and those were canceled. And 4 days later, there was a hearing on that motion to continue, and Pioneer did not show up, and nobody ever expressed any confusion that Pioneer was out of this case. But it wasn't just the
Is that
interrogatory.
a true waiver if their initial affirmative defense alleges that if anybody is dropped, any party is dropped, but basically it's a reservation of the right to apportion fault. I know it's vague.
Right, whether or not you can do that in the pleading, when you're then asked, is there any facts supporting this defense, and you say no, then under the PNC, that is a waiver. But even if you don't count the interrogatories as a waiver, so there's expert witness disclosures, where you have to disclose who your experts are going to be at trial. Up to the date of trial, they never amended their expert witness disclosures, which they would have had to do to assert a Fabry defense. They would have had to add Dr. Sweet to that disclosure to let us know that was their intent. And if you don't believe that's the waiver, then we get to their expert witness list. Because those get filed, they filed two, one on September 30th. Pioneer's not a party, dropped 2 weeks before they were informed of it. And who do they put on their witness list? They include not only Cogent experts, but they've now adopted the Pioneer experts. Experts who would testify, Pioneer doctors were not negligent. And they amend that witness list 4 days before trial, and they include the Pioneer experts again. How was the plaintiff to know that they were still holding this in their back pocket and prepare for it? And that's why 2 days before trial, which is the first time the judge had a chance to consider it, the court denied it. It cannot be said that the court abuses discretion in not allowing a person to disavow a defense up until the date of trial, only to try to reverse course. When we get to the plain language, I think waiver and the fact that they disavowed the defense takes care of that, but the plain language of the statute recognizes what our Constitution requires, and that is the legislature sets substantive rights, and the courts decide the procedure by which those get selected, by the way those get enforced. And so yes, if you have a substantive right, court procedures require you to assert it. They require you to disclose it and to provide it to the other party. And that is what was not done in this
So
case.
this is a separation of powers issue now.
Well, it is if you're going to say that the reference to the rules of procedure doesn't mean that they were recognizing that procedural rules have to apply. If you applied Cogent's ruling, then no matter what a defendant did, no matter how much they sat back on their haunches, they could drop this at the beginning of trial. This is not the way that these cases work.
What of your friend on the other side's argument that any time before trial means any time before trial?
Again, the statute references them in accordance with the rules of procedure, and I don't think you can write out the fact that the rule says justice, the fact that the rule then has been interpreted in time and time
You
again.
suggest that the interpretations don't come along with that.
I think that the statutory interpretation is exactly the opposite, right? That the legislature is supposed to know about the existing law. I don't know that they always do, but we presume that they know kind of the landscape of existing law, and that is part of what they're thinking about when they enact a statute. I want to also talk about the amendment itself, because what goes in is claims, it doesn't, first of all, it's not enough that we know what their allegations are going to be, which we didn't even know here. But we have to have time to prepare for that. And so 2 days before trial, when they can actually present this to the court, they don't say exactly what they're going to do. But it's not, even if we knew what they were going to allege, we have to be able to align those other experts. Well, might have been helpful to know that when we canceled Pioneer expert depositions, because we told them Pioneer had settled. So the judge understood. There's 2 days before trial. They're coming to the court with 4 Fabry defendants. They didn't focus on Decker. That's new. They only focused on Decker on this appeal. But they had 3 hospitalists, 1 neurologist. Hadn't told us who the experts would be. And as to referring to they've referred to our complaint, they referred to our answers to interrogatories, they referred to depositions. That's over 25 different theories of liability. So there was no even possibility that that could be addressed. And I agree that what this record suggests is that this was the fourth request for continuance, but it was a chance to get the plaintiff to have to ask for it. And the case law is very consistent on this. A judge does not abuse its discretion in denying a last-minute amendment to ad fabre at a time when the person has known for at least, even if you accept their very last date, they knew September 16th, Pioneer's not a party. That's a month before trial. They filed 15 motions in the 3 weeks between the date that they know that and the pretrial conference on October 6th. None of them mentioned fabre. They sit through the pretrial conference and they never say a word until the day after when they know it can't be heard until right before trial. The reality is the judge also got to review all of this at the end, and the judge looked at its discretionary rulings that it made. It then again found, it didn't find that it was a manifest injustice. In fact, in post-trial motions, it found that Cogent had received a fair trial. Over 4 weeks, Cogent vetted the very theory it had always planned to vet. In fact, Cogent admits in its briefing, you didn't want to point the fingers at the other doctors, that would only make us look bad. So Cogent chose its defense. It proceeded with that defense up until trial. It never disclosed a different defense. And at the end of the day, the jury found that that defense was not supported by the greater weight of the evidence. And that's why Cogent lost, not because of the judge's discretionary rulings on procedure. Thank you, Your Honor.
Your Honors, if the vicarious liability claim against Pioneer remained, which, by the way, there was never a document filed stating that claim was dropped. That is not in the record, and we've said that many times. Now, if that was never dropped, those doctors were going to be on the verdict form, and the plaintiff was going to be presenting evidence of their negligence. That's exactly why the interrogatory response says currently. That's exactly consistent with it, by the way. The only case cited for this notion of waiving things through interrogatories is 50 CA case that talks about paragraph 22 defense where the interrogatory response was no conditions preceding exist. If that case law was going to fit here, our interrogatory response would have said, if you drop the vicarious liability claim against Pioneer, we won't seek apportionment. Now, no law holds that interrogatories are evidence. They're not pleadings, and this is an argument that even that 50 CA case really doesn't address, and I think is wrongly decided for that. But an interrogatory response is a piece of evidence. If the plaintiff thinks there's significance to that, present it to the jury. It's not an attack on the pleadings, and it's not a pleading itself. It cannot waive the affirmative defense that was pled. It certainly can't waive our substantive right to then amend it any time before trial. Your Honor,
An interrogatory answers under oath. The pleadings aren't.
that's true, Your Honor, but the pleadings define the issues to be tried.
I swear, we're not going after Decker. I swear, we're not going after Pioneer.
It doesn't say that, Your Honor. It doesn't
That's
say
what an
that.
interrogatory says.
Yeah,
I swear this is true.
currently.
Correct.
Now, I want to highlight another thing about the timing.
But gamesmanship, let's go back to gamesmanship.
Sure.
You knew Pioneer was dropped in September of 2022.
No, we did not, Your Honor.
You did.
We didn't. We saw a
I
response.
found that very hard.
They used the
Start
words.
reading this whole record.
Where's the notice of dropping the party? Where's the settlement agreement? How do we know what they said? Settling isn't dropping. Settling is not dropping. That's important. Now, canceling, there's this notion about the depots being canceled. By the way, that happens in August. We don't know about the settling thing until mid-September. But even if you did measure that as the relevant point, that still can't be reconciled with the statute's language. If this court agrees with what the trial court did here, then the language anytime before trial, anytime, is superfluous, is being read as superfluous. That's not a permissible reading of this statute.
We're not to treat it as a motion, like a motion to continue.
Well, I think at that point, it's the plaintiff's issue. I mean, this is the substantive right to defense, to a defense. If the plaintiff is prejudiced by it, this court's Thompson case says ask for a continuance. By the way, if it happens during trial, then mistrial. And that's what I think this court's Rosen decision says. And I mean, I reference that because it really is the mirror image of what's going on here. But the more important part is you can't let
The Rosen decision is because the trial court made an erroneous decision, thinking the plaintiff could amend the pleadings to reflect the evidence, and they didn't.
The trial court.
What's your argument?
The trial court made an erroneous decision here, thinking we could not amend the pleadings.
Not as to this.
As to Favre,
The plaintiff said, they said the plaintiff should have amended mid-trial to reflect the evidence.
well, that is mentioned in the opinion, absolutely. And that, I mean, if that was the case here, if plaintiff, by the way, did present their standard of care expert to testify about Decker's negligence, maybe that would have been an appropriate motion here. In fact, I mean, I could see that happening, but that's not what happened here. Instead, we were precluded from presenting substantive evidence in a substantive defense, and the plaintiff got to tell the jury in closing that this person, who we're not allowed to talk about, knows everything and is the smartest person in the room, and they should believe him. If that can be challenged with substantive evidence, the whole verdict could be gone. The whole liability rules, everything could be gone. Again, this is Carter. This court has already addressed this issue. If you exclude substantive standard of care expert testimony on a substantive defense before trial, you got to do it over again. Everything has to happen over again. By the way, if prejudice is relevant, that was an abuse of discretion. Because, and I don't think it is, but if it was an abuse of discretion. We're relying on plaintiff's own evidence. There's no argument that they can make that they didn't know what the allegations of negligence were going to be, that they didn't know what the evidence was. The case law that talks about belated amendments too close to trial, it's talking about people who can't gather the evidence in time. That's not what happened here. That's not at all what happened here. The separation of power argument is not in the briefing. By the way, Judge Lucas, if they wanted the soil to come with it, they wanted the 1.190 soil, they wouldn't have said any time. That totally cuts out any case law that says, well, anytime except if it's a little too close to trial. That cannot be a permissible reading of the statute. It just can't be reconciled with the language. If we had said maybe just before trial, maybe, but they went a step further. They said any time. And again, it's coming from the backdrop of Nash here. Nash says, you better do this before trial, because what happened in Nash, they did it in the middle of trial. Obviously, there's a problem. That's also the reason why in Nash, they created the rule about the limited scope of retrial. Neither of those things happened here. The crime decision, the Carter decision, those mandate reversal here for a new trial on all issues.
You have 30 seconds.
Well, I'll just say, the notion that we presented some evidence of Decker's bad acts, I think that has two problems. One, I think that's a concession by the appellee that it really didn't change the course and scope of trial, adding this affirmative defense back in. If you really think that we did present the evidence we wanted to present, then that just proves that there wasn't a prejudice. That's another reason we trial court abuses discretion. Because that stuff happened at trial anyway. But more fundamentally, it also, that a reference to the problem with the Stewart instruction. If the trial court allowed us to present some evidence of somebody's bad acts, and then the jury was told, by the way, if you think the Cogent doctors did anything bad, they're responsible for everything else you're hearing.
This is rebuttal. She didn't talk about Stewart's. Thank you very much.
Thank you, Your Honor.
Well argued. Appreciate you giving us a lot to think about. Have a nice day. We're gonna switch.